Hello and welcome to Business on the Wire. I'm Mitali Mukherjee. In recent weeks, three benches of the Supreme Court have agreed to hear petitions that seek the striking down and the complete removal of Section 124A of the Indian Penal Code. They call it unconstitutional. Essentially, the point that is being made is that the sedition law is outdated, it is harsh, and it is cruel. Through the period of 2014 to 2019, and this is data from the Union Home Ministry, the number of sedition cases was at 326. Bear in mind, though, less than half of those actually saw charge sheets filed. And here's the stunning figure: only 6 convictions occurred out of those 326 cases. It is clear that over the last couple of years, there has been significant overuse of this law, and it has been used in both vague and often unnecessary means. At this point, many individuals are calling for an end to this law that has actually existed pre-independence and was used against some of our most marquee freedom fighters. Amongst individuals that have approached the court, there is the founder of Asianet and the current chairman of the Asian School of Journalism, Sashi Kumar. He joins me now to talk about the sedition law, to talk about the fears of state surveillance as they now exist, and why that makes the landscape quite worrying, both for media professionals and for the ordinary citizen. Sashi, thank you for joining in and speaking with me. You are now one of many that have raised serious objections to and concerns around the sedition law. Just for the benefit of people who perhaps don't understand the nuances of it, I wanted to very quickly, walk through what the law says, and then we can talk about what it is that is making people uncomfortable about the form and context of this law. So Section 124A IPC states that whoever by words, either spoken or written, or by signs or visible representation or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India, they will be and can be punished by imprisonment for life. It could be a fine, or it could extend to 3 years. So here's the context of the law. And then there are serious objections that many, including you, have raised in the court. What is it that you would like the court to observe about this, and what kind of changes do you expect to see on the law?
Well, it's very patently an obsolete, anachronistic law, which was applied by a colonial power to a colony, in this case, England against India, a law which England itself has done away with in 2009. The British Parliament has seen fit to do away with the law. It's a law under which some of our stalwarts who fought for our independence, no less than Mahatma Gandhi and Lokmanya Tilak, were charged. And I would think that it must be abhorrent to us to have the law on the statute books well until now. And it doesn't do credit to preceding governments either, such as the Congress government, which did nothing to get, to remove this law. Unfortunately, the law becomes very important now, is in the spotlight now because of the wanton use of this law for petty offenses. I think they'll pick up very soon pickpockets under sedition law, if they go at the rate that they're going. If you're protesting farmers, if you're protesting the Citizen Amendment Act, if you draw a cartoon or you write a poem against the Prime Minister, sedition is invoked for the silliest of cases. What they are doing is paradoxically trivializing the law, a law which put Mahatma Gandhi and Lokmanya Tilak in the dock. I'm saying this a little lightheartedly. Gandhi famously said that Section 124A, under which I am happily charged, he said, is perhaps among the prince of the political, sections of the Indian Code, which is designed to suppress the liberty of the citizen.
Yeah,
that is a law. So, on the face of it, it's a draconian law. And secondly, it's a law that's you just read out the law. It is so vague. By sign or by act or by writing. If I look, at how do you estimate whether I looked at you with animosity or with adverse, with malice aforethought? Who is going to read? It's psychological pulp.
Yeah.
The law, it's because it is meant for an age where it was seen as ipso facto the role of the citizen was to be obedient to the state, particularly of a colony. It was to be obedient to the colonizing power. Way back in this 18th century, in Britain, when the struggle for journalism, for freedom of expression, particularly journalistic rights, were evolving, we had this famous saying because that was the mindset in those days. Chief Justice Holt then said, if men, I'm quoting him, if men should not be called to account for possessing the people with an ill opinion of the government, no government can subsist. For it is necessary for every government that the people should have a good opinion of it. This was what was expected. People should have a good opinion of the government. This is not this is not an autocracy. This is not a monarchy where you can, by command performance, make people, say that you're great.
Yeah.
This is the nature of that law. So it had to be thrown out, and I'm surprised it's taking us so long, and to even challenge it in a court of law, and we are still discussing the pros and cons of it.
I do want to talk about what data points to in terms of the issue that you raised of too much usage of the law, but specifically with respect to how this has been viewed through the prism of journalism. I think your application as well, and you just mentioned that, is this vague and overboard nature of the law. To your mind, Shashi, is that something that has really sort of moved at a climactic pace over the last couple of years, specifically with whether it's journalists or caricaturists, all of whom are basically working under the same umbrella?
Yes, it certainly has. You can see a huge spike in the graph of the use of the law since 2016, and it's been a 166% increase in the use of the law. Not just this law, even the UAPA under the Modi regime, there's been a 33% increase. I mean, to be fair, none of these laws were brought by the BJP. They were there during the Congress or enacted under the Congress. Sedition law has the peculiar, dubious distinction of also being a pre-constitutional law. So that's another argument. Why should a pre-constitutional law or something which is on the statute continue to be, governing us now? So that is probably one of the arguments when the issue is discussed in court by all those who have challenged it. So it's being used, in a concentrated manner, in a concerted manner, in a mindless manner. It's overboard. I mean, using it in a very, very broad brush manner. And the idea is obviously not to convict anyone under the law. I don't even think the government wants to convict, because the government knows you won't get conviction. The conviction rate is abysmally low at about 3.3%.
Yeah.
So the idea is the whole idea of the process being the punishment. The idea is to have somebody as an under trial and let him have a chilling effect on freedom of expression, particularly on journalists. And the application on journalists has been peculiarly acute in this period. You see anyone who's challenging any statute or whether it's a Hathras rape incident or the CAA or the farmers' agitation, all of that is brought under the ambit of this law. So I think it's become, therefore, I mean, one is not challenging a law purely in an academic, leisurely sense. One is challenging it because this is going to be at your doorstep the next day. I mean, it may be somebody else's problem today, but it's going to be every citizen's problem tomorrow or the day after tomorrow, unless courts take serious notice of this and I think do justice in terms of throwing this law out of our statute books.
I just wanted to add some more data to the points that you raised, Shashi, and this is Union Home Ministry data. Between 2014 and 2019, more than 300 cases were registered under the sedition law. The highest was in Assam, interestingly. Charge sheets were filed in 141. So, we're at half that rate already. Just 6 people were convicted for offenses in that period. More importantly, if you go back a couple of years, the number of cases actually goes all the way down to 30 in 2015, whereas it's been escalating. What's going on here? Has this become the favorite tool? And why is it that it can be misused or used this easily?
My sense is the vagueness of the law makes it very appealing. You see, if the law is cast in watertight kind of terms, if it's cast in iron cast terms, that this is it, it becomes that much more difficult to use that law to put someone behind bars, someone inconvenient behind bars, let's say. I mean, there's no sedition involved here in the true sense of the term. Seditious libel is a concept which, again, in the 16th and 17th century, contested in England. The idea of when pre-publication, kind of restraints were given up when the Tudors left and the Stuarts came back, and under the protectorate of Cromwell. I mean, very quickly, instead of pre-publication restrictions, you had post-publication consequences. So this was applied. Seditious libel became a popular tool then to harass journalists, particularly in that period. You find a similar kind of situation, it's kind of revisiting us today. So it's useful when the law is vague to pick up someone. Not that matters. For instance, 66A, as you know, in the IT Act, 66A under the Shreya Singhal case, which was thrown out by the court, continued to be used by the police, by the law enforcers. And when the Supreme Court was angry about it, was outraged about it, the Attorney General and the Solicitor General, the Attorney General in this case, explanation or excuse was that that's because the way it is framed, that the removal is not very clear or the fine print is not clear. That is why the law enforcers are still, using that law. Now, that's a very peculiar argument. As far as a citizen is concerned, the maxim is ignorance of the law is no excuse. Are we suggesting that for the law enforcer, ignorance of the law is an excuse? So what I'm saying is, vagueness actually becomes convenient for those, because Gandhi called it, he said it's perhaps the prince of the political sections of the IPC. It's a political, there's a political intent here. The intent is not to punish someone who's working against the state, which would be a legitimate thing to do. So this is why I think this becomes a favorite tool for the law enforcer, for a law enforcer whose intentions are not, who's not approaching it with clean hands.
I have a two-part question from that. One, did you notice a regional context when you began observing or looking at the use of this law? Assam is clearly right up there, but a couple of other states, including Jharkhand, I think, are as well. And secondly, do you fear what this means in a non-metropolitan context, Shashi? As you said, when there is grievous harm or physical injury, it's easy for the lawmaker or the police officer or whoever is in that village or district to pinpoint the damage done to the law that pertains to it. In this case, it immediately becomes extremely vague, and for someone who's sitting in the deep interiors of a particular district, this is what he or she will go by.
Yes, absolutely. The first part of it, yes, as you said, Jharkhand is one of those areas where the law has been used. UP is. Bihar is, even in Tamil Nadu, they've used it, against the Sterlite agitators and so on. So, and the more you are in the hinterland of India, the more you're out there, far away from the city or from the metropolis, you are that much more a victim of it. You're that much more susceptible to it, And we don't, it's, the number of under trials in our prison system is a shame, is a blot already on our democracy. And this is creating, is accentuating the citizen that much more. The idea is that you feel constrained as a citizen, not just as a journalist, even as a citizen. What can you say? Can you crack a joke? Can you, draw a cartoon? Can you say something in public in a conversation? And now with Pegasus, you don't even know where that is leading. You don't even if you say it in private, probably that will become public by the fact that somebody is snooping on you. So that is the nature of the problem. It's so pervasive, and it's beginning to look very universalized and pervasive, which is why it's becoming a threat in the mind, in the subconscious of the average citizen.
Let me play the other side of the argument for a moment, which is that do we not at this point have sufficient legislation to prevent violence against the state or to prevent any kind of insult to national honor? Is it that we do not have a better law in place? Why is it that we are still holding on to the sedition law?
We have a surfeit of laws. If you ask me, it's an imbalanced situation where, Article 19(1) gives you the freedom of speech and expression. It speaks about freedom of speech and expression, freedom to practice any profession, freedom of movement, and the freedom of the press is also a derived right under the Indian Constitution, as we know. It's not a prescribed right. But then there is this Article 19(2) of reasonable restraints. Now you use that reasonable restraint, a qualification on a fundamental right. Reasonable restraint in Article 19 is essentially a qualification on the fundamental right of free speech and expression. You use the qualification, you use the rider, in order to enact a whole host of draconian laws. So it looks as if the rider is more important than the right. I mean, look at the paradox of it. Look at the irony of it. I have a right of free speech, but within reasonable restraints. So reasonable restraints. So in order to impose reasonable restraints, you have what? You have the UAPA, you have the Sedition Act, you have, as you said, the Prevention of Damage to Public Property Act, you have the Prevention of Insults to National, honor, or National kind of Honor Act, Epidemic Diseases Act. These have all been invoked under the pandemic. You saw Epidemic Diseases Act being invoked. You have the Disaster Management Act. Now, apart from this, of course, you have the NIA and you have the CBI and you have various agencies of the state also playing their role. So there's a bearing down on the citizen by this multiplicity of, in inverted commas, draconian laws and agencies of the state, literally to muzzle not just the press, but the average citizen. So it's not as if we don't have other laws. This has been pointed out. This is certainly is an argument which is also will be coming up in the courts when the rationale for removing sedition law is being argued.
Mm. Which way do you think the judiciary is going to view this, though, Shashi? Because at this point, early comments seem to indicate, for example, what the Attorney General Venugopal had to say, that some guidelines may be laid down to curb misuse. They've also said it's time to define the limits of sedition. Perhaps they need better interpretation, particularly in the context of media freedom. Do you expect to see a complete removal, or do you think they're just going to tweak a couple of the knobs and work it accordingly?
I'm very clear, unless this is thrown out, lock, stock and barrel, it will just be a further reading down effort. That's what happened in 1962 in the Kedarnath case. The law was, the Kedarnath held that the law is important, but then there was some qualification, some reading down took place, some dilution of it in the interest of, in what cases, how can you use it, to ensure that the usage of it, or to try and ensure the usage of it is bona fide. Further reading down of the law is not going to make a difference, because for the person who's enforcing the law, for the policeman at the grassroots level, at the police station, those nuances are of no importance. So reading down this law is not going to help the law. We saw that happen. Article 67A, which was removed, in the IT Act, is so manifestly illegal, and yet it was in practice. So widely prevalent that the Supreme Court had to intervene and say they are shocked to find that a law that they have struck as illegal continues to be enforced. So that's the nature of our polity. That's the nature of our democracy. So you have to remove the law. You have to just remove it from the statute books. It is doing justice to the idea of India, to democracy. It is doing justice to our freedom fighters, and it is important. I would have thought that a right-thinking government, a democratic government, even the current BJP government would have got kudos if they had actually got rid of this parliament, through the legislative process, like they did in England, and not wait for the Supreme Court to actually, frown upon it and throw it away, or have citizens challenge it and take it to a court and have it thrown away. They already have a multiplicity of other laws to protect for the legitimate reasons of, say, national security and interests and so on. So, as you said, the Chief Justice's observations in open courtroom are very, very, very encouraging, because he's raising precisely the commonsensical questions that we are discussing now. Why should you have a law like this on the statute books anymore? A law which, harassed Tilak and Gandhi. What is the need for such a law? But just because in 62, I think the Kedarnath, sometimes, in legal issues, half a loaf is worse than no bread. So that's what happened in the Kedarnath judgment, in my view. You kept thinking, oh, with this tampering with the law, this kind of dilution, diffusion, that's enough. But you see that it's not really helping. So you really need to throw away the law, lock, stock, and barrel. It's true that the Attorney General and the Solicitor General are arguing that don't throw it away. We can make sure that it won't be misused. But they haven't been able to make sure that in the case, that's precisely my point, in the case of 66A. They haven't been able to make sure until the court had to again intervene. And now we don't know whether it's still being misused, because India is such a huge country. Of course, they've sent out directives again, asking every police station to implement it and so on. But who knows?
There is a more dangerous context to it in the here and now, is there not, Shashi? Because we also now have allegations of state-sponsored surveillance on civil society voices, on journalists, on opposition party members. Sandwiched with something like the sedition law, this can actually be much more than just shaking someone up or trying to instill fear in someone. It goes beyond being a witch hunt, does it not?
Yeah. So these fingers of suspicion now point to the government, right? That although we haven't called it out specifically as such, because that you need clinching proof on that. But if you look at the nature of the people or the character, who are the people who are being snooped upon, it again doesn't make much sense. One can understand only political opponents. One can understand, people who have a dubious past in terms of challenging the state and so on. This is a kind of political, again, snooping. You want to know a lady who complained against the Chief Justice for harassment is being snooped upon by this Pegasus. So what is, obviously the intention is very clear to anyone who has a brain to think of. You don't need rocket science to imagine what is going on here. So and it's across the board. There are people from the ministers in the government. There's a former Chief Justice. There's a former election commissioner. There are all kinds of people involved in it. So obviously, it's pretty much to be used, just as I would argue that sedition law, against anyone you think who has a potential to become a problem or is already becoming a nuisance or a problem to the government of the day or to the leaders of the day, to the political, of the ruling party, particularly, in this case, the BJP. So that's very, very obvious. And therefore, it's more than a finger of suspicion. I think it looks very, 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 unless the government, I think the onus of proving that it is not now, the way it's going, is on the part of the government. But the government is silent about it. They are just saying that legally there can be no snooping in India, which is not saying this or that. I mean, no government would say snooping is going on illegally, right? They'll say legally no snooping is going on in India. Which
is saying that 45 other states did it, so why did you pick just us? Which almost sounds like, yes, we did, but so did the others. What does it mean though for the landscape for media and journalism generally, Shashi? Given this kind of context, given the you're almost hanging by fire with this fear of what may happen via a law or what may happen via surveillance. What do you think that it could mean for the future of journalism if we are to live with this sedition law, if there are not going to be any meaningful changes or removal completely?
Yeah, the nature of journalism is changing before our eyes, and it's almost a paradigmatic change. You find that much of the legacy media itself is looking a bit helpless now. The media which has, newspapers of record of that kind, they are influential, but sometimes they're reluctant to use their influence on the side of democracy and the citizen. Many of them, unfortunately, have, lain themselves supine before the government. Many of them have become propaganda arms of the government. I'm talking about mainstream channels or newspapers and so on. There are honorable exceptions, but what is significant, for instance, the Pegasus story is broken not by a mainstream newspaper or legacy paper, but by a beleaguered news portal, which has been seen as bold, which has been seen as speaking truth to power. And the fact that they chose to give this story to The Wire in India, along with Washington Post and other influential newspapers across the world, is actually indicative of how the needle is shifting in India. That the bold journalism is being practiced not necessarily from the quarters that we expect it to be practiced in, because some of them have capitulated or are keeping silent, which I think is a crime, as Yevtushenko famously said, when truth is replaced by silence, that silence is a crime. I think some of them are guilty of that. So some of the news portals, some of the bolder news entities are filling in that role, and therefore I think it's both a time of crisis and opportunity, of challenges and opportunity. You find how there's a new genre of journalism developing, a bold, forthright, honest, without pulling punches kind of journalism continues, is happening before us. That's inspiring as well. So you find that shift. But I hope that the journalists and the fourth estate, the fourth pillar of democracy, doesn't abnegate its responsibility at this hour of trial, at this hour of crisis. Many of them I find the foreign press, some of our newspapers talking about, or media talking about the Pegasus issue as India's Watergate moment. Whether it will be that or not, it's a useful, kind of, it captures your imagination, but whether that will happen or not remains to be seen. But I think this is a moment for the media to rally around. and make sure that the liberties of the citizen, that the power of the media, that the role of the media to inform freely and fairly, the role of the media to speak truth to power is not abridged. And this chilling, they have to get rid of this chilling, effect. This chilling effect has been going on far too long. You cannot have a media under chill, under deep freeze for so long. You have to shake out of that stupor. I hope the media will rise to that occasion. Otherwise, it's going to be a very dark period ahead for democracy. I don't think that will happen. I think the Indian people, the Indian media are resilient. I don't see that happening. But you can't help thinking that this is such a depressing moment. I don't think after emergency we have faced such a depressing, except the emergency was an explicit act of attack on the media, on the people's rights. This is as many have called it, an undeclared phase having the same symptoms and the same actions by the state.
It is also a telling comment that of the names revealed so far, there is not a single television journalist who seemed to be under state surveillance. I think that, it tells us what's happening with a large part of mainstream media. Just one final question, Shashi, just on the point you were making, at this point, it looks like pushback is getting distilled into two distinct verticals. One is individuals fighting back on the sedition law, and the other is media organizations challenging the current changes in IT laws. Would you say these two are crucial to the outcomes of what may happen for democracy over the next few years, as you said?
I would also add to that the collective efforts like farmers' agitation. I mean, that they are so resilient, they've been so adamant, so obdurate, or the citizens, the protesters against the CAA. So there have been group actions as well, collective action, in the public sphere as well. But you're right, there has to be a linkage. Not that I wouldn't say that the media should actually become part of the campaign, because the media must also be able to point out critically excesses in such movements, if any, must point out where things are going wayward, where direct democracy threatens to take over. I think the media has to step in. Media cannot allow populism to go unabated. But now what's happening is you have populism on the part of the state. You have all of these symptoms actually happening on the part of the state and some of the media extensions of the state. So I think an alliance or a sense of solidarity is important, if not an alliance. And I think that is happening willy-nilly, without any intention of it happening. It's happening because democracy, freedom is too important for all of us, whether I'm a newspaper man or a media man, or or a doctor or an engineer or a laborer or a farmer, or just a homemaker. It's too important for all of us to leave it to somebody else. I think that sense, I think, is beginning to dawn on us, and that is perhaps a good thing.
Indeed. Thank you so much for your time today, and my best wishes. I hope indeed that this is the year where we finally see an end to this draconian law. Thank you for the efforts that you're making in court as well. Thank you very much.
Thank you, Mitali. Thank you, and congratulations to The Wire for its seminal role it's playing in some of these important areas. Thank you very much.
Thank you, sir. Thank you.
To receive instant updates on all videos from The Wire, click the subscribe button and hit the bell icon. Pay to support independent journalism. Click the link in the description and choose the amount you want to pay.